For employers who utilize AI software in their hiring processes, this settlement highlights some potential risk of scrutiny by the EEOC related to those processes.
My prediction would be you're going to see AI officers, not just at a company, but inside a law department in the future to be able to keep up with it, not just with use of AI as a lawyer, but regulation of AI. Think about establishing an artificial intelligence committee, and it is going to map out policies. It's going to vet new technologies. It's going to approve employee requests for use of AI.
Welcome, and thank you for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speakers for today, Jennifer A. Riley and Gerald L. Maatman, Jr. Jennifer A. Riley is Vice Chair of Duane Morris's Class Action Defense Group and has defended companies faced with significant complex litigation matters for over 2 decades. Ms. Riley regularly defends companies facing class actions, collective actions, pattern or practice lawsuits, and other types of representative proceedings. Ms. Riley regularly develops strategies for navigating some of the largest challenges faced in corporate America today and counsels employers confronted with a range of complex theories that span from claims of discrimination to a myriad of types of alleged wage and hour statutory privacy violations. Gerald L. Maatman Jr. is chair of Duane Morris's Class Action Defense Group, has nearly 4 decades of experience of practicing law, and has defended some of the most significant bet-the-company cases ever filed against corporate America. Mr. Maatman has represented companies, executive teams, and boards across the country in class action litigation. Among his accomplishments, he defended and defeated the largest systemic enforcement action ever brought to the U.S. Equal Employment Opportunity Commission, the first Attorney General prosecution of a Wall Street company for workplace discrimination and harassment, and the largest wage and hour class and collective actions ever brought in Florida and New York. The webinar presentation that you're about to watch will be approximately 1 hour. If you have any questions that come up, we will be taking those once the presentation is fully complete, and you can submit them anytime by clicking the Q&A button at the control panel at the bottom of your screen, and we'll take those once the presentation is wrapped up. Now, without further ado, here are Jennifer and Gerald to discuss AI in the workplace, new frontiers in employment litigation.
Well, hello, everyone. I'm Jerry Maatman, and Jen Riley, my partner, is on. One of the other background material items about Jen that would be pertinent today is she just won the Law 360 MVP Award. She's one of the top 3 employment lawyers in the United States. And central to her practice and phone calls she gets every week are what to do with respect to AI in the workplace issues. So Jen and I put together this 5-part agenda to deal with the sorts of phone calls we're getting on a daily basis involving the intersection of artificial intelligence in the workplace. And we're going to talk about some of the uses, some of the risks, and then the key rulings and cases to date. I would say this is a great example of an area where technology is not in line with the law, and the law is playing catch up. The technology is evolving much quicker than the case law is. In terms of legislation, although there's lots to talk about, I think it's also an area where state legislatures, and as we'll talk about, the White House can't keep up with all of the changes. But there is government enforcement litigation out there, so we're going to talk about what is on the radar. And then we're going to end the session talking about what ought to be in your toolkit, practical things to take away from this webinar in terms of what you can do in advising and counseling your clients. So if there are any questions, please feel free to use the chat room or reach out to Jen or I after the session. Send us an email. Happy to help, happy to answer questions in any way possible. So what we'll start on is talking about those uses and risks. And so what we tried to do is put on one piece of paper kind of all the technologies that we bumped into in class actions in single plaintiff lawsuits and employment counseling situations in terms of AI. And probably the most case law would be the top two, biometric technologies and ad tech. Biometrics stemmed first, the first law involving it was in Illinois, the Illinois Biometric Information Protection Act, um, passed about 13, 14 years ago. Over 5,000 class actions have been filed in the state of Illinois, and started out basically with timekeeping systems where people would scan a thumb, or there'd be a retinal scan to determine when they were signing in and signing out. The law has been amended several times since because of what's occurred in Illinois, and pretty mature set of rules and regulations around biometrics. And that, as we're going to talk about later today in this session, has spread to other states and areas. The area where we're probably seeing the most play is what is commonly known as ad tech, or advertising that appears on websites based on people's clicks, and what are called meta data pixels, that track keystrokes and the like. And probably it started out in the medical industry with hospitals and healthcare organizations, and it's spread to many, many areas. And I'd say that this is probably the hottest area of litigation in terms of what I would call privacy-related class actions, where the theory is that the ad tech constitutes some sort of breach of privacy or breach of a statutory duty that the user of ad tech has with respect to people that would visit their website, and the ad tech would track them. But it's certainly not the only. We're seeing it with automated decision-making technologies, seeing it with clinical or online doctors, generative AI, pricing algorithms. Now it's something called ed tech and fintech, taking out after ad tech in terms of schools, universities, testing organizations, and then Bitcoin and crypto companies in terms of the technologies for online banking. So basically, it's anything that the human mind can conceive of ways to use this sort of AI-related technology, and the way in which it might interact with human beings or machines to machines. And so if we had this session 5 years ago, we probably could have talked a little bit about biometrics, but probably that would have been the only bullet point on this screen. And I think if we hold this session at the end of 2026, 12 months from now, there'll probably be 3 or 4 more bullets of developments in this area. I was fortunate enough, I welcomed the opportunity to be a guest speaker as the only defense lawyer at a plaintiff's attorneys convention this summer involving privacy litigation. And it was an eye-opening experience for me to learn about all the things that the plaintiff's class action bar is doing to track technology and think of innovative ways in which brick and mortar statutes can be used to sue companies over alleged privacy violations. And so, without a doubt, this is the fastest growing, most innovative, right on the edge of the law area in terms of what the plaintiff's bar is doing. And I think it's only going to increase, it's only going to expand. And the plaintiff's bar is nothing if not innovative, and they're looking for ways where courts will accept their case law theories to be able to attack these technologies on many fronts, including privacy-related litigation, but it's certainly not the only. So let's talk a little bit about the key rulings and cases, and I'll pivot over to Jen to start that off.
Thanks, Jerry. So, in talking about some key rulings and decisions, The first one on our list is a case called Tremblay versus OpenAI. Probably not the most interesting case because it's a discovery order, but fascinating nevertheless for what's going on here and the precedent that it sets. So in this one, it dates back to June of 2024. This is a ruling by a Magistrate Judge Robert Illman of the U.S. District Court for the Northern District of California. This case involved a group of authors who alleged copyright infringement by OpenAI. And the ruling here is one by Judge Illman, where he directed that the plaintiffs needed to produce the information relating to their pre-suit algorithmic testing that they referenced in their complaint. So this one is one of over a dozen class actions filed in the last 2 years, alleging that makers of generative AI technologies like OpenAI violated copyright laws by training their algorithms on copyrighted content. Some suits allege copyright infringement. Others are alleging that they violate wiretapping, data privacy, or other laws through their process of training their algorithms on personal information. In this one, Tremblay versus OpenAI, the plaintiffs alleged that OpenAI trained its algorithm by copying massive amounts of text that enabled the AI to produce naturalistic text outputs in response to user prompts. The plaintiffs alleged here that the outputs included summaries that were so accurate that the algorithm must have collected and retained knowledge of those ingested copyrighted works. So an exhibit to the complaint in this case displayed some algorithm prompts and along with their outputs to support the plaintiff's allegations. So in this one, as I mentioned, OpenAI sought discovery of the account settings the plaintiff used to generate those results, the algorithm's prompts and outputs that did not include the plaintiff's preferred cherry-picked results as well. The plaintiffs, of course, refused to produce this information, claiming that their pre-suit investigation was work product and that those things were prepared in anticipation of litigation for the purpose of generating and filing the complaint. That dispute went to the court for decision. The court agreed with the defendant and ordered the plaintiff to produce those account settings and produce all of those pre-suit algorithmic testing results, including the negative ones. The court reasoned first that these testing results were not work product. They were more in the nature of just bare facts. Second, that even assuming that the work product protection applied, the privilege was waived when the plaintiffs put a large subset of those facts in the complaint. Third, the court reasoned that those negative testing results were in fact relevant to OpenAI's defenses. And then finally, the court rejected the plaintiff's argument that OpenAI could simply interrogate the algorithm itself or use the algorithm to produce the same results on their own. The court explained that without knowing the account settings that the plaintiffs used to generate their positive and their negative results, and without knowing the exact formulation of the prompts they used to generate what they came up with, the defendants would not be able to replicate the results on their own. So again, this is a significant ruling. The case itself is significant as being one of the first and longest lasting in this area, but the ruling is also significant because it shows that a plaintiff cannot just cite cherry-picked test results in support of a complaint without being susceptible or without opening itself up to discovery as to how those results were generated, as well as the negative results that the plaintiff chose not to use. So it could deter other plaintiffs from filing similar cases, or more likely it's going to teach plaintiffs to be a little bit more careful in terms of their pre-suit investigations and the way they craft their pleadings. Let's look at the next one. All right, the next case on our agenda is EEOC versus iTutor Group Inc. So this one is also a case, interesting for a little bit different reason. In this one, goes back to 2023. The EEOC here filed a joint settlement agreement and consent decree in the U.S. District Court for the Eastern District of New York, announcing that it had reached a $365,000 settlement with a company called iTutor. And that settlement was to resolve the EEOC's claims that iTutor's hiring software allegedly automatically rejected applicants based on their age. This is the first EEOC settlement involving artificial intelligence software bias. So in this one, the defendant, iTutor Group, hired tutors to provide English language tutoring to adults and children in China. The defendant received tutor applications through its website. The sole qualification, though, to be hired as a tutor was a bachelor's degree. So, additionally, as part of the application process, though, the applicants provided their dates of birth. On May 5, 2022, the EEOC filed a lawsuit on behalf of a charging party who was over the age of 55 when she submitted her application, but was rejected. The EEOC alleged that once she provided her date of birth on her application, she was immediately rejected because of her age. The EEOC claimed that iTutor Group violated the Age Discrimination and Employment Act by essentially programming its hiring software to reject female applicants over the age of 55 and male applicants over the age of 60. And it claimed that the company had rejected more than 200 qualified applicants because of their age. The parties then, of course, as I previewed, ended up entering this consent decree. They requested the court to approve the settlement, enter the decree, and the monetary payment was $365,000 to be distributed to these tutor applicants. However, the consent decree also included some non-monetary relief. It required the company to develop some anti-discrimination policies and complaint procedures. It required the defendant to provide training programs on an annual basis to supervisors and managers who were in any way involved in the hiring process. It also was set to stay in place for 5 years, and during that time, imposed requirements for reporting and record keeping, as well as a monitoring requirement that would allow the EEOC to inspect the premises and to conduct interviews with officers, agents, employees, and independent contractors to ensure that iTutor was complying with the consent decree. So, as we're going to talk about in a few minutes, eradicating supposed discrimination stemming from AI software is one of the EEOC's stated priority areas. So, for employers who utilize AI software in their hiring processes, this settlement highlights some potential risk of scrutiny by the EEOC related to those processes. The next one, of course, is Mobley versus Workday. This might be one of the most popular and well-followed cases because it really is kind of the first of its kind. In this one, Mobley versus Workday, it was filed in the Northern District of California. The plaintiff is an African-American male over the age of 40 who claims he suffers from anxiety and depression. He brought suit against Workday, claiming that its applicant screening tools discriminated against applicants on the basis of their race, their age, and their disability. He claimed that he applied for 80 to 100 jobs, and despite holding a bachelor's degree in finance, among other qualifications, he did not get a single job offer. Now, Workday, of course, is a software vendor, so the district court originally granted the motion to dismiss on the ground that the plaintiff had really failed to plead that Workday could be liable as an employer or an employment agency. In other words, the plaintiff here had alleged that Workday was procuring employees for its customers, but he merely claimed that he applied for jobs with a bunch of companies that all happened to use Workday. In February 2024, though, the plaintiff was allowed to amend the complaint. And when he amended the complaint, he alleged that Workday was actually acting as an agent of the employers that had delegated authority to Workday to make its hiring process decisions, or that Workday was actually an indirect employer. He claimed, among other things, that in one instance, he actually applied for a position at 12:55 a.m., and that his application was rejected less than an hour later in 1:55 a.m., the implication being that the software programming was rejecting his candidacy without any involvement by the company using the software. Now, Judge Lynn granted in part, but also denied in part, that motion to dismiss the amended complaint. At the outset of her opinion, she noted that plaintiff alleged Workday was liable for employment discrimination on 3 theories. 1, indirect employer; 2, as an employment agency; and 3, as an agent. Theories 1 and 2, excuse me, theories 1 and 3 were allowed to succeed or to progress. First, with respect to the indirect employer theory, the court opined that the relevant statutes prohibit discrimination not just by employers, but also by the agents of those employers. So an employer cannot escape liability for discrimination merely by delegating those traditional functions like hiring to a third party. The court also accepted the agency theory. The court held that Workday could be liable on an agency theory because the plaintiff had plausibly alleged that Workday's customers delegated their traditional function of accepting or rejecting applicants or advancing them to the next stage to Workday. The court reasoned that if it held otherwise, or if it accepted Workday's arguments, companies could essentially escape liability for all of their hiring decisions by saying that the function had been handed over to someone else, or here, something else, artificial intelligence. It opined that given Workday's crucial role in deciding which applicants get their foot in the door for an interview, those tools were really engaging in conduct that is at the heart of equal access to employment opportunities. The court next also denied Workday's motion to dismiss the disparate impact theory of discrimination. The court held that the 0% success rate at passing Workday's initial screening, combined with the plaintiff's allegations of bias, plausibly supported an inference that the algorithmic tools were disproportionately rejecting applicants based on factors other than their qualifications, factors such as age, race, or disability. Thereafter, after the court issued this ruling on the motion to dismiss the amended complaint, it ended up conditionally certifying a collective action of all individuals aged 40 and over who applied for jobs using Workday's platform and were rejected. So in doing so, the court then authorized the plaintiff to send notice of that lawsuit to applicants nationwide. So this litigation, as I mentioned, has been very closely watched for its novel case theory based on the use of this software incorporating artificial intelligence in making these personnel decisions.
Jen, before we move on, would it be your prediction that in 2026, the rubber is going to meet the road? There'll be some rulings on the merits, and this may well be the most important case involving AI and the workplace that's ever been filed.
Absolutely. I agree. I think that we'll see more substantive rulings from the court, if not in 2026. Certainly, the case is going to progress to set up those rulings at some point in 2027, absent some resolution of the case. And I think depending on how the case continues to unfold, we'll see copycat lawsuits being filed under similar theories, especially, Jerry, as we're going to talk about later in today's presentation, since the EEOC is not necessarily going to be pursuing that disparate impact theory. All right, let's go on then to key cases involving the Illinois BIPA and AI. So the first case on our slide here involves facial recognition AI technologies. So this case is in re Facebook biometric information privacy litigation. This case is somewhat infamous if you haven't heard of it yet. This is one initially filed in 2015. The plaintiffs claimed that Facebook used facial recognition software to extract facial geometry from photographs that were uploaded to Facebook. The plaintiffs alleged that Facebook extracted the information without disclosing its biometric collection practices and without obtaining express written consent, in violation of the Illinois Biometric Information Privacy Act. In 2021, Judge James Donato of the Northern District approved a landmark $650 million privacy class action settlement for a class of Illinois Facebook users. So that is why I think this case is so well known, that $650 million price tag. It was really a cutting edge settlement, and it resolved the claims of more than 6 million Facebook users living in Illinois. Then it prompted the next suit, of course, on the slide, Zelmer versus Meta Platforms. Zelmer was a follow-on to the Inri Facebook case. So while Inri Facebook was filed by users of the platform, Zelmer was filed by a non-user who claimed that Facebook had collected his biometric identifiers and information from photos of him that users had uploaded to the platform. Zelmer asserted claims for violation of two sections of BIPA, one of which requires private entities to publish a retention schedule and guidelines for destruction of biometric data, and another which requires private entities to obtain informed consent before collecting and using such information. This gentleman then sought to certify a class of non-users in Illinois. This case went to summary judgment. The district court dismissed the Section 15B claim, reasoning that it would be unreasonable to construe BIPA to mean that Facebook was required to provide notice to and obtain consent from non-users who were, for all practical purposes, total strangers to Facebook and with whom Facebook had no relationship whatsoever. The court also then dismissed that Section 15A claim for lack of standing, ruling that Zelmer failed to really plausibly allege he had suffered any injury traceable to Facebook's failure to develop and publicize a destruction policy. Now, on appeal, that decision was affirmed, but for entirely different reasons. The court held on appeal that the alleged biometric data at issue, which was called a face signature, was simply not capable of identifying a person because it did not qualify as either a biometric identifier or biometric information under BIPA, so the statute simply did not apply. In reaching its decision, the appellate court relied on a declaration from a project manager at Facebook who explained that a face signature really cannot be used to identify anyone because it's a mere abstract numerical representation of a face that doesn't reveal any information about the appearance of the subject, and that it cannot be reverse engineered. So the court relied on that information in finding that the BIPA did not apply. Now, notably, the appellate court disagreed with the district court's ruling that BIPA could not be interpreted to apply to non-users based on this practical impossibility of compliance. On that point, the panel concluded that because the statute's text applies to a person's or a customer's biometric data, non-users, in fact, are protected regardless of any pre-existing relationship with the party who's alleged to have violated the statute. So two fascinating rulings there, or two fascinating results there in those BIPA cases. Moving on to other cases regarding face-related AI technologies. The first one there is Martel versus X Corp. That one, of course, involves X, formerly known as Twitter. The plaintiff alleged that he uploaded a photograph containing his face to X, and that X then analyzed the photograph for nudity and other inappropriate content using a product called Photo DNA. According to the plaintiff in that case, Photo DNA created a unique digital signature of his face-containing photograph, known as a hash, to compare it to the hashes of other photographs, and thus necessarily, according to the plaintiff, constituted a scan of face geometry in violation of the BIPA. X moved to dismiss, arguing that the plaintiff really failed to allege a scan of face geometry because he really didn't allege that Photo DNA performed facial recognition, and the hash obtained by Photo DNA could not be used to re-identify him. The court in that case granted the motion to dismiss based on both arguments. The court really found that the plaintiff really didn't make any plausible allegations of face geometry because photo DNA is not facial recognition software. Second, the court really found no plausible allegations of a scan of face geometry because the complaint really didn't include any facts about the hashes supposedly conducting a face geometry scan of the individuals in the photographs. Now, in other cases, plaintiffs have brought similar claims under BIPA involving face-related technologies performing functions other than traditional facial recognition. And those companies have really obtained some mixed results when challenging those allegations in court. So we've got some of those examples here on the slide. BIPA defendants have been successful at the pleading stage or were successful at the pleading stage in securing dismissals of a couple of lawsuits that involve virtual try-on technologies. Those include the Clark versus Aveda case, as well as Castellas versus Estee Lauder that we have listed here. Defendants have been less successful at the pleading stage, and they continue to litigate other cases, though, where software involved verifying compliance with things like U.S. passport requirements. The CVS pharmacy case was listed there, as well as Trio versus Turing Video, which involves software that was involved with detecting fevers from the forehead and whether and also could tell whether an individual was wearing a face mask. So this kind of provides an overview of the world here, and we've got some mixed results, which we have listed on the slide, relating to face-related AI technologies under the BIPA. Jerry, you want to talk about some legislation?
Sure. What we put together is a map of the world, map of the U.S. in terms of where they stand in 2025 in terms of artificial intelligence. The light green states are where a bill has been signed into law, and the very light blue is the wild, wild west where there's no current legislation, and the darker blue is where proposals have been produced. This map Jen and I used in a presentation in this subject area 2 years ago, and the majority of the states were in light blue where there was no current legislation. So there's been a lot of activity. So think about this as a patchwork quilt. And if you're going to comply with the law and you're a Fortune 500 company that operates in all 50 states, imagine the compliance headache of figuring things out in terms of what you need to do in which states. And part of that is relevant to something that happened last week that we're going to talk about on the executive order front. But basically, you would have to go into each state, figure out what the latest, greatest law is, and certainly a bunch of laws are coming into force on January 1, 2026. So the watchwords are a patchwork quilt. Now, some of the more mature laws that have been used by other states as exemplars include Illinois, because Illinois got into regulation of biometrics early on. It also was one of the leading states in terms of getting involved in regulating artificial intelligence. And so the AI Video Act is a very interesting one insofar as Illinois in 2019 became the first state to enact restrictions on the use of AI in the hiring process. It took effect in 2022. And then HB 3773 is an amendment to the existing Illinois Human Rights Act. So there are federal anti-discrimination laws, Title VII, the Age Discrimination and Employment Act, the Americans with Disabilities Act, and then 48 out of 50 states have anti-bias laws, with the Illinois Human Rights Act being like a mini Title VII, but they do have broader protections, most states, than federal or different sorts of protections. And here's a great example where Illinois amended its law. It was signed into law in August of 2024, but it takes effect in less than 30 days. It takes effect on January 1, 2026 to regulate use of AI in making employment-related decisions. Many think that it may have to involve a disparate impact theory as opposed to a disparate treatment theory. And those who aren't used to it, disparate treatment is I know who you are and I'm discriminating against you in an intentional fashion because of your protected category, a woman, your religion, your age. Um, uh, Disparate impact is what's known as adverse impact, a neutral rule like use of AI that falls more harshly on protected category employees because it screens out or disproportionately affects African American, Hispanic, female over the age of 40 candidates. And so to be able to prove a violation of HB 377, most people believe that it would require use of a disparate impact theory, a theory that the Trump White House about 3 months ago, there was an executive order saying the federal government was getting out of the business of using the disparate impact tool to regulate anything in terms of litigation, and hence the EEOC, according to this executive order, would not use the theory anymore. So seems to suggest that there's a wholesale kind of movement from the federal level to the state level in the use of the disparate impact theory, which is aligned with the use of AI in terms of regulating whether or not it results in discriminatory outcomes. Jen, how about New York?
All right. So we've got two New York, one Maryland on this slide. The first one is New York City Local Law 144. This one was passed in December of 2021. It's the first law in the U.S. requiring employers to conduct bias audits of AI-enabled tools used for employment decisions. Employers must provide all New York City job applicants with a notice disclosing that their applications will be subject to an automated tool and allow applicants to request the use of an alternative evaluation process. Then the New York WARN Act. New York became the first state to require employers to disclose whether technology or automation like AI has contributed to employee layoffs. This one became effective March 2025. The act also requires a mandatory checkbox on WARN notices asking whether job losses are related to technological innovations or automations. Then in Maryland, HB 1202, this one took effect in October of 2020. It prohibits an employer from using a facial recognition service for the purpose of creating a facial template during an applicant's pre-employment interview unless the applicant has consented by signing a specified waiver. Looking at California now. So in California, we've got the California Privacy Protection Agency. In September of 2025, the California Office of Administrative Law, the OAL, approved proposed regulations on cybersecurity, risk assessment, and automated decision-making technologies, or ADTs. Set to go into effect January 1, 2026, businesses must comply with the risk assessment regulations. Starting January 1, 2027, businesses must comply with the ADT regulations. And then April 1, 2028 and 2029, cybersecurity audit certifications are due. Next, California AB 3030. That's healthcare services. It's the Artificial Intelligence Act. It requires healthcare providers that use generative AI in patient communications to issue a disclaimer and to provide instructions for assistance. Finally, California SB 942, the California AI Transparency Act. This one becomes effective January 1, 2026. The act mandates that covered providers disclose when content has been modified or generated by AI. Note one, not on the slide, failed legislation. Governor Newsom vetoed the No Robo Bosses Act, which we all might have heard of, which proposed strict measures on how employers utilize AI in employment decisions, finding that the bill was overly broad and duplicative. So that one didn't make our slide. Let's talk for a second about Colorado, There we've got the Colorado AI Act. It takes effect February 1, 2026. It's really the first legislation of its kind in the US that focuses on what's called high-risk artificial intelligence systems. It creates a duty of reasonable care for developers and deployers to protect Colorado residents from known or reasonably foreseeable risks of algorithmic discrimination. It creates a rebuttable presumption of reasonable care if the developers and deployers meet certain requirements, including but not limited to implementing a risk management policy, conducting annual impact assessments, and providing notices and public disclosures. Here, the Attorney General has exclusive authority to enforce violations that constitute deceptive trade practices up to $20,000 per each consumer or transactional violation. So steep penalties on that one, but enforceable only by the Attorney General. Jerry, over to you for Illinois.
So I think Illinois and Colorado are kind of neck and neck on being on the cutting edge of AI regulation. Colorado's law that Jen just reviewed is probably the example of the far end of the spectrum in terms of the amount of work, effort, time, and cost of an employer to comply with that law. Illinois has proposed these three new laws, all introduced in 2025. They haven't passed yet, but it shows you what Illinois is quickly trying to do is to be kind of at the epicenter of regulating AI. The first one is the impact assessment, much like the New York statute. And it's a decision-making tool for any use for any purpose, not just like the Illinois law that was passed a few years ago that involves AI on the onboarding or hiring process. The next is a notice statute, and it would create a cause of action for consumer fraud and deceptive business practices, which is a litigation engine that most people think about in terms of labeling of cereal boxes or cans of soda, but now it would be a notification process in terms of consumers who interact with websites that are interacting with a chat box or other forms of AI. And last would be a virtual, huge expansion of the Illinois Human Rights Act. Remember, the original Illinois law just talked about use of AI when making hiring decisions. It would now amend the law of any sort of decision, cradle to grave, from hiring to termination. So Illinois really stepping it up in terms of regulating these sorts of areas. Two other notable states would be Utah and Texas. Utah has a new law which has both disclosure obligations and some safe harbors for use of it. And then Texas, a very interesting one, is modeled on both the Colorado Act and the European Union AI Act, of all things. And then at the same time, it discourages and specifies right in the law that the disparate impact theory alone is not sufficient to demonstrate intent to discriminate. And a lot of people think, well, what do you need to use then? And would it be a theory that you did testing, you knew there were discriminatory outputs, and you decided to move forward with it anyway, and you did so with intentional disregard or reckless disregard of the rights of protected category individuals, and that would be enough to demonstrate an intent to discriminate. So to be written in the future in terms of what's going to occur. So let's talk now a little bit about government enforcement at the federal level. You have U.S. federal laws. There was an AI Bill of Rights that was proposed. There were various things done in the Biden administration. There's been FTC enforcement, quite a bit of it involving deep fakes or products and the like where AI was used, and the CFPB actually issued guidance for creditors and other entities that they regulate with respect to the use of AI. So the federal government definitely dipped its toe into the waters here in terms of regulating this area. The Biden administration, however, when it extended its executive order on October 30, 2023, was really the first time the federal government had a holistic cradle to grave type of regulatory approach to AI. And at the time, it indicated that it was guided by 8 priorities. And if you look there, you see privacy, consumer protection, worker protection, and civil rights, which are all kind of those whose privacy rights have been impacted, those who end up filing lawsuits and the like. You had innovation and competition and use of AI that was for employers, entities, even government. So many people thought that this was skewed more toward Joe Q public than it was towards companies that were employing AI. Next would be White House, and the Biden White House put together an office, an OMB policy, management and budget, where it talked about addressing risks of the use of AI and strengthening governance. It was kind of a paper tiger. Not a lot got off the ground, but at least it demonstrated that the government was invested in this area, looking into this area. In fact, during the presidential campaign, first when President Biden was the candidate, and then after he withdrew and Vice President Harris was the Democratic candidate, this even made its way into presidential debates in terms of a proactive regulation of AI or a hands-off, let the states do it, let American businesses use it to innovate. I think what we got then after the Trump administration took over the White House, first an action plan in July, talking very business related and looking at AI through the eyes of business. And then last week, we got an executive order. And if you Google this and read through the commentary and newspapers, magazines, talking heads, and the like, not that any of the other executive orders have not been controversial, but this one is extremely controversial. And so there are people that make statements like, well, just like that map that we showed you, if you leave this to the states, you're going to have a lot of patchwork quilt areas of regulation, making it very difficult for businesses to comply. And you're going to have states moving in opposite directions and just making it very, very difficult. And then you have people at the other end of the spectrum saying, well, an executive order is one thing. How come there's not a piece of federal legislation? And how can an executive order preempt the entire legislative area? And they point to things like wage and hour laws, where there's a federal system, but every state passes its own wage and hour laws. And then the notion is the federal system is a floor, and then states are free to build on that floor and have additional regulation. This executive order suggests that all state laws would be out in the trash bin, and there'd be funding restrictions based on the states, and there'd actually be preemption of state laws. So query whether or not there's going to be litigation over this. I think there will be. My sense is it's going to come out of states like Colorado, Washington State, California, Illinois, blue states challenging kind of red policy documents. So put on your seatbelt. We don't know exactly what's going to happen, but you're going to have two competing systems now, maybe not listening to one another, where an employer is going to be pulled between an executive order on the federal level and a state law on the state level, and one saying it preempts the other and the other saying you can't preempt me. So query how that leaves American business and where you're going to be. So it's certainly a brave new world. Jen, let's talk about the EEOC.
All right, let's talk about the EEOC. So this slide kind of has a few bullet points of the activity we've seen from the EEOC in this area. AI is identified as a strategic priority in the EEOC Strategic Enforcement Plan, or SEP, for the years 2023 to 2027. It's kind of it's been a repeat strategic priority in recent plans. As a result, we've seen AI training ongoing for systemic enforcement teams and field offices. We've seen AI outreach events, some attended by over 1,000 people. We saw the settlement I mentioned earlier in EEOC versus iTutor Group. That was the first AI lawsuit of its kind, filed and settled in 2023. And then we had key guidance issued under the Biden administration, including guidance related to assessing adverse impact in software algorithms and artificial intelligence used in employment selection procedures after Title VII, which was issued in 2023, as well as visual disabilities in the workplace and the Americans with Disabilities Act, also issued in 2023, making it seem like AI is a focus point for the EEOC. But hold that thought for a second. Let's look at the next slide. Now we have AI remaining a key point on the EEOC's agenda, but at the same time, the EEOC announcing a shift away from disparate impact. So disparate impact, as you all probably know, it's this legal concept where a neutral policy or practice, which is neutral on its face, has a disproportionately negative effect on a protected group. It's that disparate impact theory that we often see being used to pursue claims of things like algorithmic discrimination or discrimination generated by the use of AI software tools in making employment decisions. So this is kind of I shouldn't say necessarily adverse to having AI as a strategic priority, but somewhat more difficult for the EOC to go after cases where we see algorithmic discrimination potentially, or where there's an allegation of potentially algorithmic discrimination if it's not going to pursue a disparate impact theory. Of course, this is a result. This pullback on disparate impact is a result of the Trump administration's executive order, which was issued with this new Trump administration under the title of Restoring Equality of Opportunity and Meritocracy. That instructed all federal agencies, not just the EEOC, to cease using the disparate impact theory of liability to enforce federal laws. Let's look at the next slide then. So shifting gears over to the DOJ antitrust enforcement, U.S. versus RealPage. This is a case that was brought in 2024. The Antitrust Division of the U.S. Department of Justice brought suit against RealPage and now has amended its complaint to add several multifamily apartment owners and managers. RealPage offers a pricing software that assists landlords in managing their inventory and in setting apartment rents. In its complaint, the DOJ admits that landlords, however, don't always accept RealPage's pricing recommendations. In fact, that they decline them more often than they accept them. But nevertheless, the DOJ is asserting that this ultimate pricing discretion is really immaterial when the users of common pricing software have effectively agreed on the starting point, even if they haven't reached agreement or colluded as to the final prices. Now, a similar issue came before the Ninth Circuit earlier this year after a district court had dismissed allegations regarding collusion by algorithm claims that were brought against Las Vegas hotel owners regarding their use of pricing software. That case is Gibson versus Senden. In August of 2025, the Ninth Circuit affirmed the dismissal of the claims in that case that the Las Vegas hotels were using their software provider to engage in unlawful collusion, essentially based on the ruling or reasoning, I should say, that these individual licensing agreements for shared software didn't evidence antitrust violations. And the allegations in that case really did provide for or allege any proof of an explicit agreement to fix prices, only that the software in that case used publicly available data. So in that case, the court found there were not allegations sufficient to support a conspiracy in that case because those hotels maintained these independent pricing incentives. So that suggests courts are somewhat skeptical of this algorithmic collusion when it comes to pricing, especially without any evidence of an agreement to restrain trade. Nevertheless, the DOJ seems to be taking a more expansive view, and this is definitely a developing area where we are probably likely to see some additional activity. Jerry, back over to you.
Okay. So we are back where we started, where we say, what do you do in terms of making sense of all of this? And we call it building your AI toolkit. And by that, we mean what sorts of things do you need to arm yourself with to assist your clients who may come to you if you're on the plaintiff side of the V in terms of counseling them with respect to potential causes of action against employers or website companies. If you're on the defense side of the V, how do you comply with these laws? How do you keep up with the regulations? What are the existing precedents and what should you know as a result of those precedents? I think it's a demanding area to keep up with on both sides. Maybe is a little more difficult on the defense side. And certainly what Jen and I are seeing is corporate law departments now have designated lawyers either inside the corporation or at outside law firms that are their chief compliance officer when it comes to all things AI. And that job's just getting bigger and bigger and bigger. My prediction would be you're going to see AI officers, not just at a company, but inside a law department in the future to be able to keep up with it, not just with use of AI as a lawyer, but regulation of AI by states and by the federal government and private enforcement efforts by the plaintiffs' bar and government enforcement lawsuits that are brought by the government. So what ought to be in your toolkit? So I think on the defense side of the V, one of the things you need to be thinking about is use of AI and challenges to use of AI has a lot to do with class action litigation, especially in the ad tech area that we talked about before, that this is one of the fastest growing areas of class action litigation. And so you may have heard of a decision called Epic Systems v. Lewis from 2018, a U.S. Supreme Court decision. Many people call it an epic ruling, and basically it green-lighted for the very first time the use of arbitration agreements that contain class action waivers that can be used in defense of a company that's sued in a class action that basically says the signer of the arbitration agreement can't bring a class action and has to submit to individual arbitration. And so probably 70% of corporate America in one form or another have arbitration agreements. And because the plaintiff's bar is nothing if not innovative, one of the ways they've tried to work around this is what they call a mass arbitration, where to have a fair, equitable, and enforceable arbitration agreement, an employer has to pay for the arbitration. And so by aggregating a bunch of individual claims, putting the word mass on it, I have 358 clients. They all have an individual arbitration agreement. You have to pay all the arbitration fees. Mass arbitration has been a weapon that the plaintiff's bar has used to attack companies that have those arbitration agreements. But you need to keep up with the mass arbitration rules and the things that can be done to add and amend an arbitration agreement to lessen the risk of that. And if we're going to do it, there's one case you need to read, and that's the Walrich v. Samsung decision from the Seventh Circuit, which is in essence the judicial antidote to mass arbitration proceedings. I commend that to your reading about all the ways companies can protect themselves in this area. think the next thing you need to do is think about establishing an artificial intelligence committee. And it is going to map out policies. It's going to vet new technologies. It's going to approve employee requests for use of AI and to monitor use of AI inside an organization. And this would include identifying all uses of AI by third parties that you contract with, those who collaborate with operations, those who collaborate with IT departments, those who collaborate with cybersecurity departments. We've gone so far as to recommend that for ad tech companies that are using websites in terms of interfacing with their customers and auditing the ad tech that's on there. And so having one committee that vets, looks at, in charge of, responsible for this area, we think makes not only good business sense, but good legal sense too. Next, we are talking about mitigation programs, and that is marrying the risk management department with in-house lawyers and outside lawyers. And so one of the things that needs to be done is looking at all appropriate insurance policies with respect to coverage options or exclusions with respect to the use of AI. And the insurance industry is obviously reacting to all of this area. Vendors are reacting to this area. And so one of the things are the notices or communications that go to visitors, callers, customers, in terms of describing your use of AI and what they can expect, and then detailing that with vendors in terms of prohibitions or banning certain AI or uses of AI in terms of dealing with you. So that is your grand tour of the world. That's right at our bewitching hour of 1 hour. This has the contact information for Jen and myself. Please feel free to call us, reach out, email. We run a Dwayne Morris class action defense blog, and we post items about new AI related issues all the time. Here to help, and it's been a pleasure and a privilege to be with you during today's session.
Thank you so much, both Jerry and Jennifer, for your time and your insights. We do have one question that came in, if we could quickly take that. This person asks, what AI tools are currently creating the biggest litigation exposures for employers, in your opinion, and why is that?
Well, I'll take a stab at that. And I think it's AI that assists employers in, and it goes by different names, but assists employers in the hiring function to cull through resumes and the like and to make hiring decisions. Some people call it hiring by chat box. But in essence, that's the area where employers are at risk. And then ad tech class actions where website companies and customers, sometimes employees interact with the websites would be the area outside the workplace where you'd see the most. And so the artificial intelligence goes by different names, but those are the two spaces in which we're seeing the most risk and most lawsuits.
Wonderful. Thank you, Jerry, for that additional insight. And thank you for the anonymous attendee who submitted the question. There is the contact information for both Jerry and Jennifer up on the screen if you had any questions that we weren't able to get to today or that you weren't able to ask. We want to thank you all so much for joining us for another Justia webinar. As I mentioned at the top of our presentation, we do have our innovative feature-packed website solution, Justia Elevate, that's specifically designed for law firms and gives you access to lots of AI tools that can help your marketing for your practice. That includes our Justia AI Writer, which is designed to help you create content for your website, the AI-powered Justia Chat to connect you with new leads, and FAQs for AI to help you show up in those coveted AI results. If you want to check out the pricing for your firm today, you can go to elevate.justia.com/price. Thank you all so much for joining, and thank you again, Jerry and Jennifer, for your time. Have a wonderful rest of your day. Thank you all so much. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.